one way is through talaq. You come through talaq and you dissolve the marriage. There's a legal procedure that we know this. But there is another procedure, annulment of the marriage. Rather, I can say annulment of the contract. If you're having a contract, you can say, these terms and conditions you have not followed, I'm dissolving this contract. So the right has been given to a husband and to the wife as well, both of them. They have this right. They can annul the marriage without reciting talaq. Yeah. ऐसा ना हो घर पे जाए बोले मौलाना साहब घर पे जाओ अपने खत्म हो गया मामला. But there are some conditions here. So there are two different options we are having. One option is called option of defect and the option of deception. Khiyar al-aib and khiyar al-tadlis. These are two different options. What does it mean? If there are some sort of defects in a husband or in a wife, which are defined in Islamic Sharia, Islamic laws, if these are there, in that case, the right has been given to the husband or to the wife to dissolve the marriage if they want to do. They have this right. There is no need of reciting talaq. Although the iddah and all this stuff will be there, but there is no need for that. They have this right. This is for the defect, if this defect is there. Now, when this defect should come or when should not, we'll discuss this. Another is option of deception. Deception क्या है? आपके बारे में तो हमने सुना था, आप जो हैं अल्लामा हैं, आपको तो अलिफ बे भी नहीं आती है. Yeah, you told us that you are a doctor and you are not a doctor. So you have cheated us. So in this case, if someone has cheated another party, so as in contracts, in your business transaction, it's a contract, and marriage is a contract as well. The right has been given to both the parties. Then they can dissolve this marriage contract if they want to do. Yeah. Now how this deception can be defined and all this, again the discussion is there. Yeah. So let's start. I don't know, Mahdi, what happened? I can't see the slides. Yeah. Yeah, it's there. G. Annulment of the marriage. A husband, ruling number 292. You can see P in bracket P. So P is for Persian. So you cannot find it in English, it's in Persian. If it is A, it will be Arabic from Minhajus Salihin. A husband or wife, due to the presence of certain specific defects in the other party or due to deception by the other party, defects and deception, okay, has the right to annul the marriage contract, whether it is a permanent or temporary marriage. It doesn't matter. This right is referred to as option of defect. Khiyar al-aib. Aib is there, defect is there. This right is given. And option of deception. Khiyar al-tadlis. Hope. So the details are there. So first we will describe what is the meaning of khiyar al-aib. What is the meaning of khiyar al-aib? What sort of defects? Yeah. So defects of which a husband, now we will divide this into two. So defects a wife is having and the husband can annul the marriage. Okay. So the other category would be, so the husband is having some sort of defect and the wife can annul the marriage. Okay. So for a husband it is easy. If he is not going for the annulment of the marriage, he can give talaq. The more important is for a lady. If a lady wants to use this, yeah, it's very important for her. For example, this is a reason actually that I didn't want that non-Baligh boys should be here. The husband has the right to annul the marriage due to defects, khiyar al-aib. After the marriage contract, he discovers one of the following 6 defects in his wife. Number 1, insanity, al-junoon. She is majnoon. In Gujarati, what should Mari wife Gandhi che? Yeah. If this is the case, then in that case, even if it is periodic means sometimes she is majnoon, sometimes she is not majnoon, which is a disorder of the mind. This does not include fainting and epilepsy. Yeah, epilepsy is not included, which cause temporary episodes. Number 2 is leprosy, al-judham. Third is vitiligo, al-baras. So a skin condition, the white spots are there. So if this is there, he has the right to annul the marriage. Blindness, al-ama, she can't see, which means complete loss of vision in both eyes, even if the eyes are open. However, Ayatollah Sistani says, blindness in one eye or night blindness, a condition where one cannot see at night, or weak vision that causes the eyes to water frequently, does not give this right to the husband to annul the marriage. So both the eyes are not working, she can't see. In this case, the husband has a right to annul the marriage. Lameness, limping, al-araj, even if does not reach to the level of complete immobility or permanent disability, if she has this, he has the right. 6, samahani, al-afal, the presence of flesh or bone in the vagina, whether it prevents intercourse or pregnancy or not. Similarly, vaginal adhesion that prevents intercourse is also considered a defect. So if this defect is there, so he has a right. Ayatollah Sistani now says there is a ishkal regarding the husband's right to exercise khiyar al-aib if he discovers that his wife was afflicted with ifza. Ifza, I'll not go for that. Leave this. Yes, that is very important. Now, when all these defects should arise, Ayatollah Sistani says this right is there with the husband. If the marriage contract may only be annulled due to the wife's defects, if it is proven that they existed before the contract. If he came to know that she had all these things before the marriage, then this right is there. Any defects that arise after the contract are not considered grounds for annulment. If she became blind because of you, she was cooking in front of the fire, because of that she became blind, now you want to give talaq. Sorry, and you want to annul the marriage. Sorry, you cannot annul the marriage in this case. If it was there before, Maulana, is it necessary that I should know before the marriage, or I came now? I came to know that she has all these defects now. Yes, there is no problem. If you came to know that she has one of these defects now and she had that before, you can annul the marriage. But one thing, for annulment of the marriage, the thumb rule, the rule is this: as soon as you came to know, you have to exercise this. If you do not exercise your right of annulment, your right is gone. If you do not use this. If you came to know that she was blind before and they brought me in front of me, but I couldn't figure that out, she's blind. Now you have the right. As soon as you came to know, you have the right. But you delay this. After 1 year, you say, now I want to exercise this right of annulment. No. So it should be immediately. Now what is the meaning of immediately? It depends upon the urf, how the urf is deciding that this is, okay, you have exercised this right immediately. Yeah. Is there any question here? If you have any question, you can ask. Then I can go to the right of annulment given to the wife. So these are the different defects if a wife is having before the marriage, but a husband came to know afterwards, so he can annul the marriage. Option of defect khiyar al-aib. Now be careful, the husbands. So the right is given to the wife. The right of annulment khiyar al-aib is granted to the wife in cases where the husband has one of the following two defects. Now in this case, the right of annulment was given to the husband if the lady has defect after the marriage or before the marriage. Before the marriage. But this right of annulment to the wife has been given even the husband, he has this defect after the marriage. It doesn't matter. Before the marriage or after the marriage, if it happens, the lady has the right to annul the marriage. What are these? Only two are there. Number one is al-jab. Al-jab is the complete severance of the male genital organ. The genital organ completely severe ho jata, kat jata hai wo, such that there remains no part with which he can engage in intercourse. If because of the accident, whatever happens, before or after the marriage, she has the right to dissolve the marriage. She has the right. Number 2, al-anan, impotence. So the genital organ is there, a condition that prevents the male organ from becoming erect, rendering him incapable of penetration. If this is the case, she has the right that she can dissolve the marriage. There is no need for talaq here. But as soon as she came to know, she has to exercise this. If she is not exercising her right, so the right is gone. The wife has the right to annul the marriage in the case of al-jab, complete removal or severing of the male genital organ, whether it occurred before the marriage contract or afterwards, or even after both the contract or the intercourse. It doesn't matter. Now, how to establish this? If it is established through the testimony of a trustworthy specialist doctor, a doctor says that this is the problem of your husband, okay? That the husband will never be able to have sexual intercourse with his wife and his impotence is permanent, the wife has the right to annul the marriage immediately. Yeah, if the doctor says he cannot do this in future, she has the right. She can annul the marriage. In such case, it is not necessary for her to wait for a specific period of time. Because in the next masala, we are coming that she has to wait. If it is not proven, how long will it take? Maybe after 2 or 3 months, he will be okay. It will be a different situation. But if a specialist or doctor says, no, it's a permanent situation, now there is no need for her to wait actually for another couple of months or for 1 year. No, there is no need for that. Yes, this is the issue. It is not established. It is uncertain. It is not known whether the husband impotence, which has been established through one of the methods mentioned, that how it should be mentioned, we have not discussed, is permanent or not. The wife must refer to the religious authority. I don't know. Currently, my husband, he has this problem. But how long will it take actually? I don't know in this case. So in this case, she can go to the religious authority. She can go to the religious authority and speak and describe this. This is the problem. The religious authority will do what? Will then grant the husband 1 year lunar deadline. 1 year. The deadline is there. If you're okay, that's it. If during this period the husband is unable to have an intercourse with his wife or any other woman means road par nahi bhai, any other wife. If he can have an intercourse with any other wife, as his permanent or temporary wife, then the wife has the right to annul the marriage. Then the wife has right to annul the marriage if he is not able to do that. Yani, if in the period of 1 year he was able to have an intercourse with another wife, but not with this wife, so she doesn't have the right now to annul the marriage. Sorry, Baba, but Maulana, after 4 months, what happens? Then she has to go for talaq, not annulment of the marriage. She cannot use this right of annulment of the marriage from her side. Yalla, go. No. Because he can have an intercourse with someone else, but with not you, you have to go for talaq then, not for the annulment of the marriage. Is there any question here? You can ask. Yes. Ji. Okay, brother is asking, Maulana, what is contract? I have not seen any contract and this and that. Contract in writing, it is not wajib actually. Contract means you agreed, okay, that ankahto wa kabilto, it's a contract. मैं निकाह करना चाहती हूं और आपने क्या कहा? कबिलतो, मैंने कबूल किया. That's a contract. So there are some terms and conditions by default. So these are some terms and conditions, for example. By default, these are there. If you're not able to, this right has been given. Although you can put a lot of terms and conditions. Why? Because it's a contract. It's aqd. Two parties are coming. You put as much as you can. You can put these conditions. But there are some conditions you cannot put if it goes against the essence of the contract. essence of the contract, the nikah ka jo asal hai, usse khilaf ja raha hai. You cannot put these conditions. For example, if a lady puts a condition in the contract that there is no mahramiyat between you and me, then for what sake actually you are reciting nikah then? कुछ भी नहीं होगा. Maybe आप कहीं भाई बहन बन के रहेंगे. Oh really? Then for what actually you have recited this? So up to certain level there should be some sort of pleasure, maybe touching or whatever. There should be there. If she says no, nothing, no, it is going against the essence of the contract. Nikah इसलिए था ही नहीं फिर ये. No, khul is different. Khul, जिसको आप खुला कहते हैं, khul is something different. Khul is one of the types of talaq. Talaq is talaq raj'i. Raj'i means, okay, I'll tell you. Once husband is unhappy with the wife, husband gives talaq. This is called talaq raj'i. Raj'i means that he can refer. For example, he gave talaq to his wife, and after 2 days, he feels, I should not have given talaq. Then he can refer. Without reciting any nikah, he can go back. There's no need of that. This is called talaq raj'i. Second one is both of them, they are unhappy. That is called talaq mubarat. Okay, both of them, they are coming. One is only wife is unhappy. This is talaq khul'. Again, it is type of talaq, khul'. So once husband is upset, unhappy with the marriage, he is going for the talaq. Once wife is going for the talaq, that is talaq khul'. It is part of the talaq. And the third is both of them, they are unhappy. So for khul, if she is going, who has to give talaq, by the way? Talaq has to be given by the husband. Yeah, it doesn't mean khul ka matlab ye nahi hai, wo jaake talaq mangega, wo padegi sab kuch. No. She is proceeding for the talaq. She is the one who came for the talaq. So that is called talaq khul. In that case, husband ke paas right hota hai, itna paisa maal lagaya tha maine tumhare upar, shaadi ke upar, itne million lagaye the, nikalo mere paise. Then he can demand in this case, in talaq khul. Yeah, because you are upset. I'm happy actually with the marriage actually. There is no problem. You are upset. Then there are different procedures. Yeah. Wife, if she does adultery, that is this a matter of talaq? No, there are cases actually, if she commits adultery, what to do in Quran, there is a whole procedure, what to do actually with this. Okay, that slowly and gradually, that remove her from the bed, and then at the end, up to certain level, that the hitting is there as well. Then there are procedures, it's a different thing. But it's not a matter of talaq or automatic annulment of the marriage, that you can annul the marriage. No, that's not the case. That's not one of the conditions that because of that you can annul the marriage. Or the husband has done zina, so wife says, sorry, go away from here. No, that's not the case. Yeah. Khalas. A group of scholars, I leave this, I leave that. Yeah, that is important. Infertility. That's a good thing, huh? Infertility is not considered among the defects that grant the right to annulment, neither for the husband nor for the wife. Yeah, infertility is not the case for annulment. Yeah, the right of annulment due to defects applies equally to both permanent and temporary marriages. This is what I said. Immediate exercise of the right of annulment. If you came to know, use this right. If you do not use this right, and if you delay this, after some while you came to know, no, not came to know, you want to exercise this right is gone. This is what Al-Tali Sani says. I'll finish this here. So what should be the immediate? What is the definition of that it should be immediate? Customary immediacy. Al-fawriya al-urfiya. What the urf says, what the common people says, that yes, you have done this immediately. Within a period of 1 week, maybe. If you feel within 1 week, you say, yes, she has taken the decision immediately, or he has taken the decision immediately. You feel that is immediate. Okay, there's no problem in that. But for example, someone is taking a decision after 10 years. Will you consider this as immediate? No. So from where the immediate effect will start? From where will it start? Since he came to know or she came to know. That's the time. So from that moment it will start. As soon as she or he came to know, he or she has the right to annul the marriage. It is required when exercising the right of annulment due to defects, whether in the man or in the woman. कोई सवाल हो तो ठीक है, मैं यहाँ पर ख़त्म करता हूँ. खुदा करे कि हम इस मामले तक नहीं पहुँचें. बट आप देखें, इस्लाम ने रूल्स और रेगुलेशंस बनाए हैं और आपके पास राइट दिया है कि आप एक्सरसाइज करना चाहें उस राइट को, ताकि आप ये ना समझेंगे इस्लाम ने कोई ज़बरदस्त आपके लिए दरवाज़ा बंद कर दिया. नहीं, दरवाज़ा बंद नहीं किया है. आपके पास एक राइट है, कॉन्ट्रैक्ट है आपके पास. अगर आप इसको यूज़ करना चाहें तो यूज़ कीजिए, यूज़ नहीं करना चाहते हैं तो यूज़ ना कीजिए. वस्सलामु अलैकुम व रहमतुल्लाहि व बरकातुहू.